Welcome to Tilikin Gibbons webinar on best practices for dealing with similarity citations of trademarks in Thailand, Vietnam, and Indonesia. My name is Kasama Siwatanakun, counsel from our Tilikin Gibbons Bangkok office. Today, I have my colleagues from our Vietnam team, Mr. Son Thai Huang and Ms. Carolina Olaiputi Chaidi from our Indonesia office with me as well. Just a housekeeping note. So we will be having a Q&A session towards the end of our 3 presentations. But if you have any questions during the meantime, you can type in the chat box and we will try to answer them at the end of the sessions. So I believe that most of you, if not all, are already our existing Tilikin Gibbons clients, colleagues, and other subscribers of our Tilikin and Gibbons newsletters. So you all must already know that we are a leading regional law firm established since 1980s in Thailand. And we also have our offices in 6 countries in this region, in Bangkok, Thailand, Hanoi and Ho Chi Minh City in Vietnam, Jakarta, Indonesia, Phnom Penh, Cambodia, Vientiane, Laos, and Yangon, Myanmar. But today we are only focusing on Thailand, Vietnam, and Indonesia first because due to the time limitations. But in the future, we may have similar sessions for our remaining offices. So if you are interested, please stay tuned to our next sessions in the future, which we may announce later. So before we begin with our presentation, I would like for our speakers to introduce themselves first. So I would be starting for Thailand. So as mentioned, my name is Kasama. I have been working at Tilikin Gibbons for almost 20 years now. So I've been in the Bangkok office for 18 years, and I also have a chance to work at our Jakarta office in Indonesia for 2 years. My main practice areas is trademark. So anything that relates to trademarks from pre-filing advice, trademark search, trademark filing until registration. And I also do IP commercialization, which means that I advise on the utilization of IP. I do IP due diligence. I do review and advise on IP-related agreements, such as franchise or license agreements, and also any other IP that, any other agreements that may related to IP, such as perhaps movie production agreement. So now I would like my colleagues, Mr. Son from Vietnam, to introduce himself to everyone a little bit. Please, Son.
Thank you, Khun Kasama. Good afternoon, everyone. Again, very well welcome to our webinar today. I am Sơn. I am a senior associate in IP group of Tilikin and Gibbons in Hanoi office. And so far, I have been practicing trademark matters and commercializing IP rights in about 18 years, including 7 years at Tilikin Gibbons. And during the past year, I have had numerous clients to protect and commercialize the IP rights to overcome complicated actions issued by the IP Office of Vietnam, as well as to obtain successful decisions on trademark opposition, cancellations, and invalidation action. And today is my great opportunity to share with you some insights on how to deal with similarities of trademarks in Vietnam. I hope you will find our webinar interesting and informative. Thank you.
Thank you, Son. So please, Carolina, please introduce yourself to the audience a little bit.
Good afternoon, everyone. My name is Carolina Olaiputi Chaidi. You can call me Nina. I'm working in Tilikin Gibbons Jakarta office. I mainly handle all trademark matters from pre-filing, like trademark searches, filing, post-registration maintenance, enforcement, and litigation. Other than trademarks, I also handle industrial design matters. I've been joining Tilikin from 2020, and I've been enhancing my knowledge in intellectual property in Tilikin Gibbons. Hope you enjoy our webinar today. Thank you.
Thank you both. So let us start by talking about Thailand first. So the law that relates to citations in Thailand are mainly the Section 20 and Section 13. There are two different sections, but it's quite similar in terms of it's a citation from an earlier confusingly similar trademarks or identical mark that was filed before the applied mark is being filed. And it relates to similarity citation of a trademark in same class or even in related class as well. The difference between Section 20 and Section 13 is that for Section 20, the registrar will cite an earlier pending applications, whereas in Section 13, it's a citation against registered trademarks. So why the difference? It's because that's the consequences of each section is different. The way that you should handle these specific citations are also different depending on the strategies of the applicant. So for the starts, I would like to mention about Section 20, which is a citation of the earlier application. So this means that the earlier mark has not proceeded to registration yet, and it also means that it is unclear yet whether that earlier application will eventually proceed to registration. So at this stage, if we have received the office action based on Section 20, we will inform the clients that in this section, you do not really have to file an appeal or any response to the trademark office. This office action is going to be on for information only, but it is very useful because if in case you found that there is an earlier application which is filed by your distributor, a local distributor, which not supposed to be filing an identical or similar mark to yours, but they file it. So you may want to consider negotiating with them to have them transfer that earlier application to you. Or if you found that a third party has maybe bad intentions or bad faith in filing this earlier trademark before you, and then you found it by the information from this citation under Section 20, it is time for you to monitor that earlier trademark so that you may be able to file an opposition against that trademark before it proceeds to registration. So I would say that actually you can appeal against the similarity citation for a pending mark under Section 20, but we usually really don't recommend because you can wait to see first whether that earlier cited mark will proceed to registration. And if it later proceeds to registration, then it's going to be cited against your registration again under Section 13. So once you reach you receive the citation under Section 13, that is the time where you need to do something. Otherwise, your trademark application will be considered dismissed. So I would like to note that again, Section 20 is for pending application that is filed earlier before you. So if it is possible for you to file an opposition before it proceeds to registration, it will make that problematic go away before it has become a citation under Section 13. So it's a good time because filing opposition in Thailand is usually easier to accomplish than filing a trademark cancellation action against registered trademark. Another observation that I would like to make here is because many of our clients have usually asked about cross-class citations, whether it's possible. So in Thailand, it's very possible because for both Section 20 and Section 13, the law specifically said that it's possible that a citation will be in other different classes that having similar characteristics to the goods. And that's very broad description. So we have seen mostly that many times there are filings in class 35, like for retail services, for clothing. Your trademark in class 35 may be cited against trademark registration in class 25, which is relating to clothing because you have mentioned the retail of clothing. So what to do when you face the citation under Section 13, which is the the rejection that you really need to do something, otherwise your trademark will be abandoned, as mentioned earlier. So first thing first, I would suggest that you should consider whether this citation can be discussed with the registrar first, whether it's possible to revoke the citation. This is particularly recommended approach when, if in case you file a multiple class trademark applications and the problem only happens with one citation from one specific class in earlier mark. So if it's possible that you delete the entire class from your application, that's problematic, then you may be able to get your remaining classes go towards registration on the condition that you can talk with the registrar first and discuss whether it's sufficient to delete just one problematic class or not. Otherwise, you may need to proceed with the normal appeal. I note here that it's not possible to have a divisional application. So that means that if you were to decide to remove some of the classes that were cited, then it means you will lose the rights in that class. You will have to file the new application for that deleted class. Another scenario where you may want to consider with the registrars whether a revocation of citation is possible is in case of there was an error in the instructions. Like it happens sometimes that due to the oversight of the registrar, they cite a later filed trademarks against an earlier trademark. So we can easily inform the registrar that this is an error, so they may revoke the citation. Or even the citation against an expired trademark. So sometimes the trademark office have not updated the database to say that this trademark is already expired. So it could sometimes happen. So we can talk to the registrar to revoke the citation so that you don't have to go through the appeal process. Another possibility is the citation due to inconsistency of trademark owner names and address. This happen quite a lot because in Thailand, in Thai words, when you file an application for foreign companies, when we have to state how the names is transliterated or written in Thai. And in one English word, we may transliterate into many ways. So if you instruct several lawyers to handle the trademark application of the same entity, it's very likely or possible that different lawyers will translate or transliterate the names differently. So that could cause a citation. The same way as a minor discrepancy, like I put example here, ABC, comma, versus ABC dot, comma. So even if one dot could happen, could have the citation happen, or sometimes in some address do not have zip code, but in another application do add a zip code to it. So it's also happen possible for the citation for these minor differences. But this can be fixed by making all of the applications containing the identical names and address, and then you can discuss with the registrar whether they can revoke or not. But this option to revoke the citation, I would like to mention that you need to be careful of the deadline because it's not a common approach that the registrar would revoke easily. It's not all the time that they would agree to revoke. So if they don't revoke by the deadline, it means you have to file an appeal with the Board of Trademarks to keep the applications pending, even if your situation is only the difference of the dot, one dot that makes difference. But if the registrar doesn't agree to revoke by the deadline, you need to file an appeal. And sometimes the registrar doesn't really issue a citation, but they just issue an informative office action, like saying, okay, I think you filed an application for ABC company, but another application is ABC dot company. Maybe it's the same company. Do you want to change first? We also see this type of office action, which is quite good because it means the registrar hasn't rejected your application yet, and it's time for you to do something to correct the discrepancy, and then the application will move forward. So if you cannot revoke the citation by the registrar, it means you have to file an appeal with the Board of Trademarks. So for the appeal, we separate it into two types. A formal petition, which is a shorter version of the appeal. So maybe you cannot get the registrar to revoke a citation based on an expired trademark. So now this is the time you file a formal petition saying that the earlier citation was already expired. And then we submit the proof that it's expired within 60 days afterwards. And a full appeal can also be filed to argue against the dissimilarities of the trademarks. So that's a normal appeal. You also can submit 60 days afterwards evidence of use to prove that it's dissimilar, or evidence of use to prove that you have been honestly and concurrently used your trademarks together with the cited trademarks. So for honest and concurrent use claim, I note that in practice, we must submit quite a large volume of evidence. So that means at least 500 pages in papers and showing use for more than 5 to 7 years. So otherwise, it's very difficult to get approval by the trademark office based on this point. Another scenario that maybe it's possible to get a coexistence of a trademark is special circumstance under section 51/1, which I will later discuss. But just for this page now, I would like to mention first that an appeal takes around 4 to 5 years now due to backlog at the trademark office. So if it's possible, that's why I mentioned that if possible to revoke at the registrar stage is better, but otherwise you have to keep in mind that it's going to take quite a long time. And if this satisfied, you still may be able to proceed further to the IP and IT courts, which is going to take quite some more years too. So now special circumstances under section 51/1. The text here may sound a little bit confusing. It says the assignor, assignee, inheritor files an application for a mark that is identical or similar to the trademark she or he assigned it, accepted, or inherited before in the same class, having same nature, blah, 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 and received written consent. So to put it more simply, I put an example here. So if there is a mark X1 filed by company A, and then company A assigned to the company B. Now company B will be the owner of marks X1. And this scenario makes the party eligible for being considered as special circumstances under section 51/1 because company A now is the assignor of marks X and company B is the assignee for marks X. So this means that in the future, if company A is to file mark X2 in the future, they may be accepted for registration, even if X2 is similar to X1. But if company A, which is the assignor in the first application, if company A can get a written consent from company B, then the mark X2 will be accepted for registration. Similarly, make mark X3, which later may be filed by company B, it could be cited against the mark X2, which is now under company A, right? But if the company B can get a written consent from company A to support the mark X3, so the company B will be able to register the mark. So in other words, section 51/1 is the only circumstances that written letter of consent is going to be accepted by the trademark office in Thailand. Under section 51/1, there is no really explicit requirements on the letter of consent, but there is a guideline to examination of trademarks in 2022. So in that guidelines which was published by the trademark registrars. They said that the letter of consent must at least have the following information, which are: first, it must have details of the assignor, assignee, or inheritor of a trademark. So if that trademark was assigned so many times, then you need to submit an interrupted series of the assignment or inheritance to show that the chains of title is complete. Secondly, there must be details on the date of assignment written on the letter of consent. And the date of assignment must be before the date of filing the new application that you want to use that letter of consent to support your application. So that means that you cannot wait until the citation happens and then proceed with the assignment and then submit the letter of consent. Section 51/1 doesn't work that way. You have to have previous assignment before the date of filing the new application. And also an original letter of consent is required, but it doesn't mean that if you file 10 applications at the same time, you would need 10 separate original version. No, we only need one original version to be submitted for the first application, and then we can cite in the remaining 9 applications that there is the first original application on which particular application number, and that's sufficient. So points to notes for section 51/1 here is that this special circumstances only applies to assignor, assignee, inheritors. It doesn't apply to any other types of relationships like unaffiliated companies or any other relationships. So the law is very specific on how to use section 51/1. And there is a concept that we use to try to fit in that special circumstance, which is called assign and assign back of the trademark. But this will have to happen, as mentioned earlier, it has to happen before the citation occurred. And we must have, since we have to write down the dates of the assignment or inheritance of the mark, so the transfer or the inheritance must take place before the filing date of the new application. And lastly, the letter of consent should be submitted to the registrar at the time of filing or at the time of receiving the office action, not to be submitted to the Board of Trademarks, simply because, as I mentioned in earlier slides, that appeal to the Board of Trademarks would take 4 to 5 years. But if you submit the letter of consent at the time of filing the application or at the time of receiving the rejection, it's going to make it much faster for overcoming the citation under the Thai laws. So that is the end of my slides for Thailand. Now I would like to share the floor to our colleagues from Vietnam office. Mr. Son, please.
Thank you, Kun Kasama. Similar to Thailand, the right to trademarks in Vietnam are established on the basics of registration in accordance with the first to file rule. Therefore, before issuing a decision on granting protection of mark, the IP Office of Vietnam proactively conduct the search to see if there is any prior mark that are similar to the applicant mark, and then issue a similarity citation. And therefore, the similarity citations in Vietnam very normal. But in our webinar today, I will mention some similarity citations which I view that they are notable, such as the citation due to the dissections of element mark, citation due to confusion with expired mark, citation due to the slight differences between the applicant name and the cited trademark of the name and our address. And then I propose some option to overcome the similarity citation. And the first similarity citation I'd like to mention is the likelihood of confusion test on these sections of constitution element of mark. In practice in Vietnam, during the substantive examination, the IP office often dissect its constitution element of mark and then compare such element with the corresponding element in the prior mark. And as a result, many applied from mark may be refused just because they contain elements that are identical or confusingly similar to particular element in the prior mark. And as you can see from the slide, the applicant mark aware automation for good in class 9 were refused protection due to likelihood of confusion with the mark Cisco partner aware for the same kind of good in class 9, just because the applicant mark contained the word element aware identical to the element aware in the prior mark. And we know that the basic principle in determining confusion between marks is that marks must be compared in their entirety and must consider in connection with the particular goods or services for which they are filed or registered. And certainly, a particular element of mark should be given more or less weight in determining the likelihood of confusion. For example, a dominant element of mark will be given more weight than the generic terms or descriptive term. But the conclusion on likelihood of confusion should rest on the considerations of the mark in their entirety. This is because two marks sharing the same element will not automatically result in confusion between them. And therefore, to overcome this type of similarity citation, we often advise our client to argue against the merits of the refusal using the argument I have said. And in addition, submitting evidence showing the coexistence of the mark outside Vietnam and also the co-registration of the mark outside Vietnam is also helpful to support the argument on the likelihood of confusion between the mark. And now I will move to another notable similarity citation in Vietnam, is the citation due to the likelihood of confusion with expired prior mark. Under the Article 74.28 of Vietnam IP law, an applicant mark will be refused if it is confusingly similar to a prior mark that has been expired for less than 3 years, except when the case the prior mark were cancelled on non-new ground. And before the first days of January last year, when the old IP law became into effect, the period of time when an expired mark can be cited again later files confusingly similar mark is 5 years rather than 3 years, lies in the current IP law. And to overcome the similarity citation, we often advise our client to obtain evidence issued by an authorities in Vietnam, such as VTIC and agencies under the Ministries of Industries and Trade of Vietnam, or the Market Bulletin under the Ministries of Finance of Vietnam, showing that the cited mark have not just been used in Vietnam in 5 years before its expiry date, and then argue that due to the non-use status of the cited mark, the public in Vietnam will have no recollections of such mark and will not confuse the applicant mark with the cited mark to overcome the citation. And certainly, alternatively, the applicant can approach the owner of the cited mark to obtain a declaration attesting the non-use status of the cited mark to respond to the provisional refusal. And the next notable similarity citations in Vietnam I'd like to mention now is the citation due to the inconsistencies, the trademark owner names and or addresses. In practice in Vietnam, one entity with even slight differences as to the names or address is often viewed as different entity. Despite this fact, we sometimes very surprised to see a similarity citation at this time. And as you can see from the slide, the applicant mark video rows divide will refuse just because the applicant name contains no letter I standing for Italy, like its address recorded in the old registration. And therefore, the IP Office of Vietnam cited the old mark vendor owned by the same holder to bar the registration of the new mark. And to overcome this similarity citation, we often argue that both addresses refer to the same location. However, if there is actual chain of name and or address of the trademark holder, the client should file a request for recovery of chain. Thirdly, to avoid this type of similarity citation, we often advise our client to use consistent addresses and name in all trademark application file before the IP Office of Vietnam is possible. And in the next slide, I will present on some alternative options to overcome the similarity citation, such as taking actions against the cited mark, obtaining consent letters issued by the owner of cited mark, negotiating with the owner of cited mark for assignment thereof to the trademark applicant, and others alternative action. And in case if we view that the chance of success in overcoming a similarity citation by argument will not be high, we will then advise our client to file an opposition against the prior mark independent or a cancellation or invalidation action against the cited mark if it is justiciable when applied to, among other options. And for opposition, as the applicant had not just had any mark in Vietnam, the most common ground for oppositions is that the cited mark is confusingly similar to the applicant mark, which has been widely used or well known in Vietnam, or the cited mark will find in bad faith in Vietnam. And the applicant can also file an invalidation against the cited mark on the same ground as in the opposition if the cited mark is registered. And meanwhile, a non-use cancellation action is feasible if the cited mark is registered for more than 5 years in Vietnam, but had not been used for the 5 years prior to the request for cancellation action. And one of the notable points in our current IP law is that the inclusion of bad faith ground for opposition, refusal of mark, and invalidation action against a trademark just been amended in the 2022 amended IP law, which came into effect on the first day last year. And under the old IP law, bad faith cannot be an independent ground for opposition, refusal of mark, or invalidation action. Therefore, the IP office were often reluctant to issue a decision to refuse a trademark applicant or to invalidate a trademark registration on bad faith ground. Given the law amendment, a trademark holder and the IP office now will finally be granted to initiate action or to issue relevant decisions on bad faith ground. And in case the trademark applicant initiate a non-use cancellation actions or invalidation action against cited mark, the applicant can request the IP Office of Vietnam to suspend issuing a decisions on the reachabilities of its mark until the non-use action or the invalidation is completed. And the next option to overcome the similarity citation is to obtain a consent letter from the cited trademark owner. While consent letters is common in many countries, including Thailand, like our customer had just mentioned, in Vietnam, there is a big change of practice regarding consent letters. In the past year, a letter of consent of the earlier rights owner are often sufficient to overcome the similarity citation, unless the two marks are identical or virtually identical. However, at present, a letter of consent could help to overcome the similarity citation in a case-by-case basis only when the rectified mark is not very similar to the cited mark, or the two-party mark belong to the same group of company. More importantly, even when the two-party mark belong to the companies of the same group, a consent letter will not automatically be sufficient to overcome the citation. As you can see from the slide, the IP office reasoned that the word element sinopac in the applicant mark is the dominant element, which is identical to the cited mark. And in addition, because both marks were filed and registered for the same kind of group in class 9, the IP office viewed that the contemporaneous use of both marks by different entities will result in a likelihood of confusion in the public. So far, therefore, the IP office refused the applicant mark, even with a consent letter from the cited trademark owner. For the reason, if the two-party mark can be viewed very similar to each other, the trademark applicant needs to consider other options. For example, negotiating with the owner of cited mark for assignment of the cited mark to the trademark applicant, or to deleting the same or similar goods or services to negate the confusion between the mark, or to wait until the cited mark is registered for 5 years in Vietnam and then take non-cancellation action against it to remove it from the register, along with refine the applicant for the same or similar mark. Now I will go forward to my final slide on procedures to contest a similarity citation in Vietnam and the relevant timeline. And in Vietnam, a trademark applicant will have at least 3 opportunities to contest a similarity citation issued by the IP Office of Vietnam against its mark. First, within 3 months from the issuance date of the provisional refusal, the trademark applicant can file a response to the examiner in charge of the case, asking him or her to reconsider the similarity citation. And then, if the examiner does not agree with the response and issue a refusal decision, the applicant can file a first appeal to the appeal department belonging to the IP office, asking it to reconsider the case. After that, if the applicant is not happy with the decision on settlement of the first IP issued by the IP office appeal department, the applicant can file a second appeal to the Ministries of Science and Technology. This is the higher authority supervising the IP office performance, asking the minister to reconsider the case. And in addition to the appeal proceeding within 1 year from the receipt date of decision on refusal, or the first appeal settlement decision, or the second appeal settlement decision, the applicant can initiate a court case against the refusal decision in the administrative court. In practice in Vietnam, due to a lot of backlog, it could take the applicant about 1 year from the filing date of response to the intended refusal to obtain the decision on protection of its mark or to reform its mark. And then it takes about 2 or 3 years to obtain a final decision on each appeal state, for example, in the first appeal state at the IP office, or the second appeal state at the Ministries of Science and Technology, or 2 or 3 years of each state of court action, the first instant action or appeal state. And that brings me to the end of my contents on notable similarity citations in Vietnam and options to overcome them. Now our colleague Kalanina in Indonesia will continue with her presentation there. Thank you for listening.
Thank you, Kunson. I will share my presentation. Good afternoon, everyone. On this opportunity, I will share the practices for dealing similarity citations in Indonesia. Refusal based on similarity citation is the most common issue when filing trademark application. Based on Indonesia trademark law, an application is rejected if it has substantive similarity or identical with first, prior registered mark or prior application of other parties in respect of similar goods. Second, a well-known mark of other parties for similar goods. Third, a well-known mark of other parties for different goods. And fourth, a registered geographical indication. Point 1 and point 2 is the most common cases we found, which is rejection based on similar goods or service. However, with point number 3, it opens the possibility of citation that occur cross classes other than similarity with well-known mark for different goods. Citation occurs cross classes is based on bad faith, similarity with well-known marks based on opposition from other parties, examiner's knowledge on the mark, and for if a multi-class application receive rejection based on cited mark that only cover one class, usually it will affect the other classes. For example, if an application covering classes 9, 36, and 42, while the cited mark only registered in class 9, usually it will affect the other classes, class 36 and 42. To overcome the citation based on similarity, the applicant can argue on the similarity, which will not create confusion to public. And the applicant may show registered trademark that can be co-registered with the cited mark, which previously accepted by the examiner before. And then other than similarity, citation due to inconsistency of trademark's owner's name and or address is likely to happen too. An applied mark is possible to receive a refusal due to similarity with a trademark owned by the same applicant if there are differences in the name or address. For example, there is a change of address or a change of legal entity. To overcome this, the applicant can argue that the name or address refers to the same applicant or submit recordal of change of address or name. Here, for example, company PTABC become a public listed company where the company names become PTABC TBK. If PT ABC TBK files new trademark application without changing the company name in their prior trademark, it is possible that their new trademark application is rejected based on their prior registered mark that's still recorded as owned by PT ABC due to differences in the name of the applicant. Therefore, it is important to always update applicants' detail for name and address to prevent citation based on their mark. In the past, minor dissimilarity was likely to happen, but currently it is not often happening unless there are significant name or address differences. Further, citation due to similarity with expired trademark is also likely to happen. An expired trademark, but still under a grace period, is possible to be cited against a later filed application that has similarity. Here, for example, Mark Katz was applied on 4th November 2022, then received provisional refusal on 28 August 2023. The applied mark is refused based on similarity with Mark Katz, while Mark Katz has expired in 8 April 2023, but the grace period is still 6 months after 8 April, which is 8 October 2023. This is likely to happen because the examiner considered that the cited mark is still open for renewal and possible to be active again where the later filed application that has similarity should not be registered side by side. However, to overcome this, the applicant can submit a response arguing that the cited mark is within a grace period and has not been renewed. The TMO examiner will wait until the end of grace period for their consideration to accept for registration. It is often that refusal like this resolves until filing an appeal. And then other than similarity with registered trademark. In rare cases, similarity citation occurs based on the following cases. First, similarity with legal entity that registered as an applicant in the prior mark. For example, application mark Diane refused based on similarity with legal entity name Diane Limited. Second, similarity with transliteration of trademark registration containing non-Latin characters. For example, mark NECO was refused based on registered trademark NECO written in Japanese characters. And third, similarity with letter application. For example, markets filed on 13 January 2020 rejected based on market Z filed on 13 March 2020. However, point number 3 sometimes happen because of the error by DTMO. However, in our response, we can argue that the cited mark was filed later than the applied mark, which should not hinder the registration of the applied mark. To overcome the citation, we can file a response by DTMO. This is the timeline starting when a provisional refusal is issued. Then the applicant is entitled to file a response within 30 working days since the date of the letter. Then the TMO will re-examine the application, then decide whether to reject or to register. If the TMO rejects the application, they will issue a permanent refusal where the applicant is entitled to file an appeal before the trademark appeal commission within 90 working days. Then the TAC will examine the application and decide whether to register or to reject. If after the decision of appeal is rejected, the only measures applicant can take is filing an appeal before the commercial court. Here, the period for the TMO decision and the TAC decision is an estimation where shorter or longer period may occur depends on the workload of examiner and TAC. Other than responding to professional refusal, these are alternative options to overcome the refusal, which is approach third party, court action, and refile trademark application. The first alternative is approach third party, where there are two options can be applied, which is filing letter of consent or conducting trademark assignment. First, letter of consent. To date, there is no specific regulation that the letter of consent would resolve a refusal. However, we have a precedent case in which the TMO accept the letter of consent in allowing a letter mark to coexist with a similar prior mark where the cited mark was owned by their holding company. Recent development, letter of consent is accepted between two companies that are not related. However, in our recent case, the two companies is between unrelated Japanese companies. However, the acceptance of letter of consent is ultimately left to discretion of examiner, as a letter of consent is accepted on case-by-case basis. The formality requirements for letter of consent is notarized letter of consent and an official document showing the relationship between two companies if it's under the same group. And then the second option is trademark assignment. Trademark assignment is where the applicant can transfer the ownership of their mark to other parties. If the applicant received refusal based on cited mark owned by their group company, other than filing a letter of consent, the applicant can file an assignment to the related company. Or if it's not related, the applicant can negotiate to purchase the cited mark, then assign the cited mark to the applicant. If the assignment is submitted after receiving provisional refusal, the applicant can file a response stating that the assignment has been filed for the examiner's consideration in deciding the acceptance of the response. If the assignment process passes the period to respond to the provisional refusal, which is 30 working days, the applicant may request a suspension of examination for certain of time until the assignment is complete. However, there are exceptions for trademark assignment in Indonesia where assign back strategy is not allowed. For example, here the application CATS owned by ABC Limited was refused based on the registered mark CATS by DEF Limited. Then ABC Limited assigned the mark CATS to DEF Limited to overcome the refusal. After the mark CATS is registered, DEF Limited would like to assign back mark CATS to ABC Limited. This second assignment will be rejected by the TMO as DEF Limited should also assign mark CATS to ABC Limited as both marks have similarities. This assignment strategy is rejected by the TMO examiner as it will return to the initial situation where two trademarks that have similarity is owned by two different entities. Other than approaching third party, there are alternative options that the applicant can consider, which is filing court action, where in Indonesia, the available court action is non-use deletion and cancellation lawsuit. First, non-use deletion, based on Indonesia trademark law, non-use deletion can be filed if the mark is not used after 3 consecutive years from the registration date or less use. However, there are recent developments where, based on Constitutional Court decision number 144 dated July 10, 2024, the period mark for mark that can be filed for non-use deletion is extended to 5 consecutive years from the registration date or less use. And the second, cancellation lawsuit. A cancellation lawsuit based on similarity can be filed within 5 years from the registration date, while cancellation based on bad faith can be filed in unlimited time. Once the applicant filed cancellation against the cited mark, the applicant can request a suspension of examination for the trademark application until the cancellation is completed. Therefore, the examiner can pause their examination on the pending application. And the third alternative is refiling new trademark application, where in this strategy, the applicant may consider to exclude similar goods or service with the cited mark, include additional distinctive elements such as adding logo, registered mark, company name, or whole package of the mark. And third, at the least alternative options, the applicant can monitor the status of the cited mark and refile if the status showing that the mark is expiring and no renewed has been filed. So that's cover all of the points I wanted to share with you today about dealing with similarity citations in Indonesia. In conclusion, when filing trademark application, a refusal based on similarity citation is likely to happen. Other than filing response agreeing dissimilarity, there are several alternatives such as filing a letter of consent, trademark assignment, filing cancellation, or at least refile new application. Therefore, to prevent refusal, I suggest that it's important for an applicant to conduct trademark availability search to discover the potential risks. Thank you for your attention. Feel free to ask in the Q&A box if you have any question, or you can email me to karenina.c@telco.com.
We thank you very much, everyone, for attending and for your joining our presentation, and we hope that it's useful to some extent. Of course, please feel free to write us an email or reach out to any of us if you still have further questions or need any assistance. We welcome any comments, or if we can provide any responses to your emails, we will do as soon as possible. So I would like to close this session. Thank you very much for all attending, and we hope to be able to share our more sessions or future topics whenever appropriate. Thank you very much.
Thank you very much, everyone.
Thank you, everyone.